Okay, so before we get too far into this, I do want to point out the team at Mannor Law Office or Law Group. Honestly, we've done a lot of good things. Couldn't do any of it without them. I tried to be a solo practice attorney that didn't have much of a team, and didn't work out so well. We were lucky enough to get some really great people. So I'm going to actually ask the team. I think they're kind of lined up over there. So we've got the three attorneys. I don't know who this guy is up there. He's much older than me, the one in the corner there. I'm not sure who that guy is. But so then we've got the three attorneys. So everybody, they mentioned earlier that everybody was in the gray Mannor Law Group shirts. But then the attorneys actually wore attorney uniforms, which is suits. We've got Kelly Kingpenner, who you've talked to, you've heard from already. We also have Melissa Dixon, who's the other attorney in our office, in the attorney suit over there. And Melissa, one of the things that Melissa does for us is some of the other more standard type of legal planning, like guardianships and conservatorships. So one of the things, sometimes people thought that, oh, well, Bob and his office only do certain things. They don't do guardianships, and we don't send it to Bob if there's a guardianship. We do. We've got the staff now. It's one of the things that that I'm very proud of the growth that we've had, is to be able to offer these additional services, to be as well-rounded and to be able to do all of the different things that can be available. So Melissa's on board now to be able to help us out with making sure that we can efficiently deal with any of the court process, decedents' estates, after death, things like that. We've got Carrie. Carrie's my rock. Where are you, Carrie? And Carrie has been with me longer than anybody. There was a point where it was me and Carrie and one other person who hasn't been with us for 10 years now. And so she kind of keeps the trains on the track and keeps everything going. You met Rachel and Ina. Like I said earlier, I couldn't be prouder to work with them. They do amazing things. They've saved lives, and I say that with no question in my head that there are situations that they were able to get involved in, that they were actually able to create a care solution that resulted in people getting back to a quality of life that they never would have had before. Amy, so a lot of you have some interaction with Amy, because Amy's our Medicaid specialist, and so Amy is amazing. Amy could teach and train and run circles around most Medicaid attorneys that I've ever met. Her knowledge of Medicaid and her ability to think through these very, very complex issues is bar none. I have not seen anybody else that, especially who's not, hasn't gone through 20 years of experience with Medicaid and 7 years of, going through college and law school, but she knows her stuff. You've heard from Katie, of course. Without Katie and Rachel, we wouldn't have a boot camp. They're really the big push behind boot camp to make sure that everything happens the way that it is. Kat. Now, some of you know Kat because she was actually in the industry for a while. Kat was a business office manager at a couple different skilled care facilities. We did not poach her, I promise. If there's any bosses in the audience, we did not poach her. She had already left. She had put in her notice. She said she was not going to be working in that industry anymore. And then we said, well, if you're clearly not working there, then come and work for us, because she's fantastic. What she does for us is something that a lot of law offices don't have, which is that what we call the funding process. So we talked earlier about trust and how important it is to retitle assets and go through all the beneficiary designations. That seems like it shouldn't be complicated, right? Just to retitle assets, do beneficiary designations. Seems like that should be simple. It is one of the more challenging things in life to do, especially with some of the older folks that are not fully understanding all of the assets they have, and maybe they grew up with parents that were in the Great Depression, and so they were told to have, lots of eggs in lots of baskets, and so they have an account at each bank in town. And so Kat is able to sort through all of that, and she's done an amazing job for us with regard to helping those clients. We've got a few of the newer team members that have joined us this year. So Cynthia has been holding down the fort today. So you're not going to get to meet Cynthia. She's back at the office, answering phone calls, holding down the fort. We have Wendy. Wendy comes to us with, I don't know, a couple of years experience at least. You know, I was going to say a bunch of years experience, but then that sounds like I'm saying you're old, which you're not, because you can't be old because you're younger than me. So that's not okay to say that. So she worked for a judge for many years, and then has a lot of years of experience within the legal industry. And then Irene joined us. How long have you been with us, Irene? Has it been about a month, 2 months? So one of the reasons I wanted to specifically point out Irene is anybody that works in the long-term care setting, you might start getting calls from Irene. This is something that we just instituted about 2 weeks ago, and we've got an amazing feedback from that. We're going to, if we have an active case with you, if we have an active Medicaid case, one of the key things that we want to make sure is that you have the opportunity to get information from us on a regular basis, and we have an opportunity to get information from you on a regular basis. It's very stressful when it's Medicaid pending, right? Everybody, you know, your bosses are saying, why is it Medicaid pending for so long? Why aren't we getting paid? You know, all these types of things. So our idea, and what Irene has been able to do very effectively, is she's going to start doing communication with anytime there's a pending case or a pending Medicaid application, she's going to communicate either with the business office or the social worker or whoever you want her to communicate with to make sure that you're updated once a week. And now the feedback that we've got mostly was, this is phenomenal, this is great, this is, you know, it's perfect because I get a call from my boss every week saying what's going on with this bill. So Irene's going to hopefully preempt that. So you'll get a call from us prior to that call from your boss, and you'll be able to say, well, this is exactly what's happening. Now, some of you might be overwhelmed by that and say, I don't need a call a week. She's still going to reach out to you once a week, but most people are really grateful for that call a week. The other ones, we're going to adapt to you, and you say, okay, I don't want a call a week. We're still going to update you either with an email, you know, something, so that we're communicating. If it's an active, pending Medicaid case, we're going to communicate with you once a week. And this is something we just instituted, and the feedback has been phenomenal. And Irene just does a fantastic job with it. It's one of the advantages that we have. It's something that I'm most proud of, is this team that we've developed. I could not do all the stuff that we do without this amazing team, and it's the difference between working with a group that can provide all this services and communication, and working with somebody else. The fees are not going to be that different, honestly. The fees are not going to be that different with somebody that is 10 minutes out of law school and us. It might be a little bit different, but the bottom line is it's a matter of, can we get the job done? Is Medicaid application going to get approved efficiently? If there's a hiccup with the Medicaid application, are we going to stand behind our work and push it through the system and get approved? One of the things I wanted to talk to all of you about is we start all of our office meetings. We have once a week office meetings, and we start every office meeting with wins. It's something I really enjoy doing. The wins are to start everything with a positive. And so we talk about our either personal wins or our professional wins, what's happened good that makes us feel good about it, to start off every meeting. So I want to share some of my wins, or the group's wins with you. And we have more than I can mention, but I did want to mention a few of them. One of them that came through just a couple days ago. So we're going to talk a little bit about veterans benefits in a minute here, and we talked a little bit about them before. How many people have had any interaction with the Veterans Administration? Is it the easiest government bureaucracy to work with? It is probably the most difficult government bureaucracy to deal with. Our accredited claims agent that we use, his background is in environmental science. So he was used to dealing with the Department of Environmental Quality and the EPA, which is considered to be one of the worst bureaucracies in the world. And he says that was a piece of cake compared to the Veterans Administration. And so the bottom line is, dealing with the Veterans Administration can be incredibly frustrating. And what we normally do when they try to give us a denial, or they're trying to deny benefits, is we try to just keep pushing and keep that advocacy instead of filing a formal appeal. And the reason is, if you file a formal appeal with the Veterans Administration, it's not like court where you can just go into court. It's not like Medicaid where you can even just go into court, but there's time limits. The VA makes up their own rules. Right? So we end up, if we appeal a veterans case, it could go on for 10 years. It really could. And so we try not to appeal. So we try to put pressure on the VA. We'll call the Senator Stabenow's office or one of the other federal politicians and have them put pressure on it. And we've had a great amount of success using that leverage to get the VA to follow their own rules, right? We had this one case recently where it had been going on for a year and a half. And the VA just kept saying no. And finally, we said, okay, what you're saying is not factually accurate. You're saying, that this is pink, and it's not pink. It's just not. You can't say it's not. And their answer was why we were denied. They pretty much put in writing. I'm summarizing slightly, but they pretty much put in writing, you're denied because we said so. We don't have to explain it. We're denied because we said so. And we consider this matter closed. This was after contacting Senator Stabenow's office and everything else. So if they're going to be that stubborn, then we had no choice but to file an appeal. I'm digging my trenches. I'm thinking this is going to be a 10-year battle, and we're going to fight this out because we're not going to settle for that answer. Within 1 week, we filed the appeal. Within 1 week, we got a response saying, you're right, you win. It's going to be, and you're going to get that veteran who is very much in need and was running, going to basically have to cancel services soon if we weren't able to get the benefits, is getting back pay of $45,000. And so that appeal was successful because we just kept, the tenacity of keeping through it. So that's one of my big wins for the year. I mentioned earlier that I have some opinions, and one of those opinions is that the Attorney General's Office of the State of Michigan is being overly aggressive in trying to find ways to deny seniors benefits in ways that don't make public policy sense or anything else. It's not going to save money. It's probably going to cost more money. And so I'm pretty adamant about this. So my next big win is Kelly King Penner, who you just heard from, has been beating up on the Attorney General's office, the Assistant Attorney General who shows up on our cases, and she's won every single case. So they show up at our cases when we go to court. The Attorney General's office shows up and says, you can't grant these benefits. To the probate judge, you can't authorize this. And Kelly King Penner has won every single case against the Attorney General's office so far. So that's one of my big wins. And then there's a bunch more, but the final one is, when Medicaid goes wrong, or they make a bad decision, or they're just being stubborn, which sometimes happens, and by being stubborn, they say, well, I didn't receive something, and we have proof that they did receive it. So they say, oh, we didn't meet a deadline, and we have proof that they did receive it. Sometimes we get denials based on things that we already sent them. And there's other reasons why they deny. So the appeal process for Medicaid is you ask for what's called a fair hearing. And so we've won all of our fair hearings this year. And so that's another big win for us. We've won every single one of them where we challenged the denial. So those are our big wins. Just wanted to talk to you about that. Really, it is all about the great people that we've been able to accumulate. Wanted to talk one other thing before we really jump into these hot topics, is what to expect from us if you do refer someone to us. You can call us, or you can have them call us. We find that, a lot of times having them call us is spotty. You give them our information, but they may or may not call us. So if you want to call us, you can. We're more than happy to have that. We provide a free screening, okay? Not everything's going to be free. Sometimes we have a free consult, sometimes we don't. We have to look at the circumstances. Sometimes all they need is an hour of our time. Honestly, sometimes all they need is an hour of our time. If that's the case, I'm probably going to have to charge them for that hour. If I'm pretty sure that they're going to need our services going on, I might bring them in at no charge, okay? It's going to be dependent case by case. But we're always, 100% of the time, going to provide a free screening. So if they're just unsure about what benefits are out there, whether they can qualify for additional Medicare benefits or additional Medicaid benefits or waiver benefits or veterans benefits, we will always do that free screening. We're also going to listen to their story. One of them, Rachel and I were speaking at University of Michigan. They had a class for social workers at the University of Michigan, and Rachel and I had an opportunity to speak for the last several years. And she was speaking in front of the class, and I realized I had just sat with her earlier in the day, and she sat with this family for about 2.5 hours listening to their story, figuring out. Most of the time, you're not going to have the opportunity to do that. You've got too much of a caseload. You've got too much going on. There's no way you're going to be able to sit with the family and really spend the time that's necessary sometime to come up with this plan and help this family through that. And Rachel had done that. And so it happened, the day of that she had a big presentation in front of her rival school. She's not a big fan of the University of Michigan. So, anyway, so we're going to listen to the story. If we can help, we're going to set the appointment. If we don't help, if they don't need our help, we'll try to get them information where they can get help. Let us know that you referred them. Sometimes you want some feedback from us. Well, if we don't know that you referred them, sometimes they call us and they say, yeah, there was this really nice person that told us, I can't remember her name and I can't remember where it was from. So if you want some feedback, hey, did they ever contact you? Are we helping them? You let us know that you referred them and we will follow up with you. Of course, the client has to give us permission for that. Okay. All right, let's jump into this. What's new since last year? So we're going to do the hot topics update, and I've divided this into 3 sections. The good, the bad, and the ugly. All right, first let's start with the good news. This one is really cool. So this is actually another win. I didn't include this in the wins, but this is a big win for us. So they changed the rules back in January of 2017 with regard to IRAs. Now, nobody really used that new rule. It makes it so that there's a planning option to be able to protect retirement assets. And why is this so important? Well, let me give you the example. And so we were the first in the state of Michigan to use this and push it through and get it approved. And so as a result of that, we've had a bunch of attorneys throughout the state calling us saying, well, how did you do that? What do you do? What are we going? And so that's another reason why that I keep getting asked to talk is because of this particular provision that we were able to get pushed through the actual use of it. Here's what happened. You've got what I call a young couple, right? A young couple means 60s and 70s. That's a young couple to me, right? So they're in their, this couple is a really young couple, practically infants. They were in their 60s. And so one of them has Parkinson's, right? And we've known, and they've actually been clients of ours for years. And the wife worked, but never really, didn't work in any place that had a 401k or an IRA and didn't make as much money as her husband. And so pretty much all of their money, everything they had, was tied up in his retirement asset, his IRA. What would have happened in the past? We had 2 choices. We could just spend his IRA, and she's left with nothing. And she's in her 60s, and she's very healthy. She might be around for another 30-some years. And so she'd be left with pretty much nothing because, in the wheel of fortune of life, her husband ended up with Parkinson's, okay? And he needs 24-hour care. There's no way that he needs 24-hour care. There's just no way around it. She cared for him for years. It's gotten to the point where that's not possible anymore. And so in the past, we would have had 2 choices. We would have either had to spend the money and it'd be gone, or we would have had to cash it all in. What happens if you cash in an IRA? You got to pay taxes, but because you're cashing it all in 1 year, you pay higher taxes. So 40 cents out of every dollar would have gone to the government before we even were able to protect anything for Medicaid purposes, before anything. So this new provision that we were able to use and get pushed through DHHS and get pushed through to get approval on it, we were able to preserve that IRA for this young spouse, the 60-some-year-old spouse, so that we can get Medicaid to pay for it, and she's not going to be impoverished for the rest of her life. Okay? Seems like a great plan. This has always been the federal law. Michigan has never accepted it. We pushed it through. Now this is policy in Michigan. Okay? So I'm really excited about that one. Kelly talked about this physician order for scope of treatment. You guys are probably going to really like this. Anybody in the long-term care industry, you're probably going to really like this. And the question was, what's the difference between this and a DNR, right? Well, here's the big difference. A DNR, how many different forms of DNRs have you seen? Just, lots. Yeah. How do you know whether it's legal or not? Do you know whether it's legal? I can tell you the one big difference is what happens if you call the paramedic. We've always advised people, if somebody has a DNR, don't call the police until they're dead, right? Don't call the paramedic. Because if you call a paramedic, they're not going to stop and call up their lawyer. Okay, 1-800-LAWYER, I've got this document, I need to find it. No, you call a paramedic, they're going to resuscitate. That's what they do, it's their job, and you shouldn't, and they shouldn't have to they shouldn't have to be lawyers in order to be EMTs, right? And so the big difference here is this is going to be a standard document that should be accepted across the board. It's a physician's order. It's not just a legal document. It's a physician's order. And the idea of this physician's order is it should be able to be accepted by the police officer. It should be able to be accepted by the hospital. It should be able to be accepted by the EMT. And so if it's a standard document, it's going to be used across the board. And now, how does the doctor know whether to sign a post document, a physician's order for scope of treatment document? Well, the physician can look at a number of sources to say whether we know what the intent of the patient is, okay? Is it that they signed a DNR? Great. Then the physician can sign the post document. What if they didn't sign a DNR? But maybe there's other evidence that they wanted to have a DNR, that they intended to do it, but they don't have a legal document in place. Physician's able to use their discretion to say, okay, this is what the intent is. We're going to allow nature to take its course. We're not going to have to hook them up to a respirator or whatever, especially if they have advanced Alzheimer's or something like that, okay? So I think you guys are going to, next year we're going to talk about this and like, oh, post, you're going to want to educate me on the use of post, hopefully next year. Now, I don't know if it's going to take off that quickly, but they're working on a standard form. There's a committee that's putting it together, and I think you guys are going to like this. I think it's going to clear up some of this where the doctor signs it, and it's going to clear up a lot of these issues for you, okay? So I'm excited about that, too. This is another good one. Oh, my goodness. So if any of us work with younger people that have special needs, okay, that are on disability or Medicaid, but they're not 65 yet, right? And so many people have a special needs trust. A special needs trust might be a special needs trust that is done by the parents, or it might be a special needs trust that was done with money that was with the person with special needs. In other words, from a lawsuit settlement. Because grandma left them money and didn't set their planning up right. So grandma leaves the grandson with Down syndrome money. Grandson could lose his disability benefits because if he's on SSI, could definitely lose his Medicaid. And now, if grandma had set it up right, they wouldn't have lost it. If grandma's planning was done properly, then we wouldn't have lost it. But this happens all the time. Money is distributed to somebody who's eligible for disability benefits, for SSI, for Medicaid, and they lose it because of this. Well, we can take that money and put it into a special needs trust. And Congress authorized this back in 1993, so it's been around for a while, right? And so they made a mistake. They said, okay, the document, this trust, can be signed by a parent, a grandparent, a legal guardian, or a court. Who did they leave off the list? That's the person. How many people that have special needs, are we saying that everyone with special needs can't make their own decisions? Can't make their own legal decisions? Of course not. Just because you have special needs doesn't mean that you're not a person and you get to make your own decisions. And Congress left that off. It was a mistake. It was clearly a mistake. Even in the legislative history of it, it was clearly a mistake. And from 1993 to 2018, we fought to have that added, and it just didn't happen. Well, this year, was it this year or last year? I think it was this year. Anyway, they finally passed, and one of the organizations that I'm actively involved in, called the National Academy of Elder Law Attorneys, we were the biggest force in lobbying to get this pushed through, and it's called the Special Needs Fairness Act. It means the person with special needs can sign their own special needs trust, okay? There's still some kinks to work out. Social Security Administration still hasn't quite figured this out yet. Even though the law has changed, Social Security is still catching up, but they'll catch up, and this will be a great thing so that people can have their own self-determination. This is another really great thing. We talked about this, if you were at Bootcamp last year, we talked about ABLE accounts, and I said, well, we're still trying to figure this out a little bit, not really sure exactly how this is going to work and what it was intended for versus what it works. This is actually a really fantastic program. The ABLE accounts were set up through the federal government, and then each state has to set up their own procedure, and you don't have to choose the one for your state. So you could be part of the Michigan ABLE program, or you can be part of the Ohio ABLE program and the North Carolina ABLE program. And not every state has it, but many do. And if your state doesn't have it, you can use the different states. And the idea is you're able to, put money towards this. So the person themselves, the disabled person, instead of doing a special needs trust, so let's say it's a small amount of money. You got $10,000, you put $10,000 in a special needs trust, you got to pay the lawyer, you got to do all this administrative stuff. It's just not worth it. But you put $10,000 into an ABLE Act account, and now you're still eligible for benefits. Now, it's also much more flexible as to what you can spend it on. So the money is managed by whatever state is managing it. So Michigan has an ABLE account, and the state of Michigan manages that fund. We actually like the Ohio account a little better. It's a lot more user-friendly. There's a North Carolina account where they give you a debit card. That's kind of cool. So somebody who's capable of managing some of their own money So the person with special needs, they could have their own debit card, because you can't, whether it's special needs trust or able account or whatever else, usually they're not able to have a spending account, or at least not much of a spending account. But if they're able to manage a small, some of their money, one of the states allows them to have a debit card. And so that they would be able to, and you can use it, we can spend it for more things than you can spend money for with the special needs trust. Special needs trust has restrictions as to what you can spend on. Able accounts are much more generous. So what about going on vacation? It's possible under an able account, okay? And there's tax deductions and things like that. So this is really a great program. This is the moon thing that we talked about. This is where they're trying to make it so that it's clear if you're in the hospital in observation that you've been notified of that. I'm not sure exactly how it's a notice, so anytime people get paperwork, they can get a little overwhelmed, and not sure if this is having the impact that it's intended to have, but this is also a good thing. Again, mildly good. So Medicaid used to provide a deduction of $60 if you have a guardian. So mom's in the nursing home, daughter's appointed guardian, daughter can be paid $60 a month. That's not going to be considered a Medicaid penalty. Well, they upped it to $95. So daughter, who's probably going there every single day and spending money on gas and everything else, now at least gets $95 a month instead of $60 a month. All right, so this one. So this one's going to seem, kind of got printed over there, but this one's going to seem a little bit, you question whether it's good or bad. But let me tell you about Mary Ann. So in order to learn about Mary Ann Hagedorn, I got to tell you a little bit about the history of Medicaid and dealing with spouses. So under federal law, and in Michigan, for about 18 years, there was an option that we had that if we had a spouse that was not in the nursing home and a spouse in the nursing home, that we could preserve some additional assets with a special type of trust. Most lawyers call it an SBO trust, solely for the benefit of. So solely for the benefit of the spouse. And it was law in Michigan, and we used it frequently to make sure that the spouse wasn't impoverished. So that the healthy spouse wouldn't have to, sell their house or not pay their mortgage or whatever it is, so they wouldn't impoverish the spouse. And we were able to put some assets in there to prevent spousal impoverishment. And this was in the federal law. And it was in the state law. And we used these trusts for 18 years. And then one day, they said, oh, we made a mistake. That's not the law. This is the state of Michigan. Said, we made a mistake. This is not law. We're changing our interpretation. So they didn't change the law. So generally with things with the law, if they're going to change it, they got to give you warning, right? So it's like you're driving down the street and you see the speed limit sign that says 55, and you're driving 54, you're saying, okay, I'm cool, I just saw the speed limit sign. And then you pass the sign, and then they change the sign and they say, oh, it's only 35 here. And then they pull you over and write you a ticket for going too fast when you just saw the sign that says you can go 55, but they changed it after you'd passed that. And they say, okay, now we're going to ticket you because we changed the law after you drove that path. That's exactly what they did here. They didn't even change the law. They didn't change anything. They just said, we changed our mind, you can't do this anymore. Not only did they say you can't do it anymore, so that's one thing. So that's pretty awful to do that in the first place, right? And second thing is they said, okay, and anybody who's currently done it and is in the system currently and is Medicaid pending, we're going to deny you too. So you've already done it. You've already relied on it. We're going to deny you too. And that's exactly what happened to Mary Ann Hagedorn. So Mary Ann Hagedorn, she was a spouse, and she was able to preserve some assets in the special needs trust. The Medicaid application was filed. For whatever reason, it got stuck somewhere. It was sitting on somebody's desk, or it went back and forth to Lansing, whatever it was, and it went on for month after month after month. So she filed the Medicaid application in February. It was still not approved in August, and in August they said you can't do that anymore, even though she had done this in February when it was still legal, even under their interpretation. And they said, we can't do that. And so this case, and it's actually, there's a number of cases, but Mary Ann's is the lead case, went up to the court, and they won. Cool. So the local judge said, no, come on. I went to law school. This is the judge saying this. I went to law school. You can't do that. You can't change the law after the fact. That's not allowed. And the judge said, no, you can't change the law after the fact. This is the way it is. Mary Ann wins. Attorney General of the state of Michigan decided to appeal that case. So they appealed it to the circuit court. And the circuit court pretty much rubber stamped whatever the Attorney General's office said. And so they denied it. And we thought SBO trusts were done. That was like over, 2 years ago? 2 years ago. I don't know, close to 2 years ago. And so we pretty much thought we can never do this planning again. We can never help make sure that impoverished spouse isn't going to get impoverished through this technique now. We got other techniques, right? We got other strategies. But this particular strategy was no longer available. The good news is the Supreme Court has taken this case up. So the Michigan Supreme Court has taken this case up, and we don't know what's going to happen. But one of the groups that we support and we raise money for and things like that has come up with this legal support fund. We have some money to be able to take this case up. We've got some really excellent attorneys arguing this case before the Supreme Court, and our hopes are high. So that's why this is considered one of the good guys, or the good ones. This is a weird one, but I guess it's good. If you go back to Old English law 500 years ago, you'll find out what they call dower rights. Have you ever heard of dower? And dower rights was that back in 500 A.D. England, and a man would die, sometimes his wife would be impoverished, because if the man didn't set things up properly, his widow would basically in the poorhouse. And so in England, 1,500 years ago or whatever, they said, well, can't have that. So we're going to make sure that women have an interest in their husband's properties. They never said it the other way. The husbands don't have an interest in their wife's properties. And so this law has been on the books for the last 1,500 plus years up until 2017. And so all this time, and it actually went to court, and the court said, they argued, and they said, well, that's gender discrimination. You can't give women a right that men don't have. And the court said, we don't really care about that. So the court even upheld this. And so it had been around forever. We just all accepted it, that women have an interest in their husband's property, but men don't have an interest in their wife's property. Well, the Congress, or the state legislature, the Michigan legislature, changed that rule. So they've gotten rid of dower. So it may not be on the good side of things. Consider most of the audience as women. You no longer have an interest in your husband's property if you're not on the deed. If it's only his name on the deed, you no longer have an interest in it. So that might be another reason why you want some legal planning to make sure that if he dies, you don't end up homeless here. All right. Kevin's Law. This is an interesting one. This is regarding mental health. And so Kevin's Law was passed back in 2005. It encouraged outpatient treatment before somebody reaches a crisis or hospitalization. So this is somebody that's possibly a danger, but here's the reason why it wasn't very effective. It required a person to be in imminent danger to themselves or others before anybody could act. So, like these high school cases that we're hearing about, and they say, the police were called 27 times. And the police say, we couldn't do anything because there was no imminent danger to self or others. We talked to them, and we thought, this kid's weird, and there's really potentially a problem, but if we can't prove imminent danger, which is a high standard. So they've changed Kevin's Law in Michigan to change it a little bit, make it a little bit easier, and we'll see how this works out, to say that if a person requires treatment when an individual is unable to understand their need for treatment and is at risk of substantial harm to themselves or others in the near future. So hopefully this change in the law will make it so that we can be more proactive. We don't have to wait until somebody has to be institutionalized, basically, or in prison, that we can get in front of this and hopefully be able to get them the necessary treatment if they be a danger of themselves, a substantial harm, which is a difference than before, which was a higher standard. Okay, now the bad guys. All right, the Attorney General might come up a few times in the bad guys section. He's currently running for governor. I don't know if anybody. Okay, Katie doesn't like me saying that. So. All right, so here's the first one. Now we've talked about this for the last few years, but it's getting worse. So Betty Jensen was a woman that was trying to do the right things. She wanted to stay in her home. What did we talk about earlier? Who wants to stay in their home if they can? And so Betty wanted to stay in her home. And so she said, okay, I want to stay in my home. Her family wanted her to stay in her home. Family came visit her all the time. They needed to supplement it. So they got this neighbor who was willing to come by and help her out and help her get dressed in the morning and make sure that she had food, make sure she was taking her medicine. And from the period of March of 2011 to May of 2011 to March of 2012, she helped her almost every single day. And during that time period, she paid $19,000. Is $19,000 too much to probably pay for care for less than a year? That's nothing. I mean, she probably wouldn't even get minimum wage. Honestly, she probably didn't even get minimum wage. There's no question in the record that this person did the services, did the work, was paid less than what their value was, certainly less than the market rate. Local DHHS worker said, "Oh no, that's going to be penalized. You can't do that. You can't pay somebody for care in your home." Really? That seems odd. And so the local caseworker misapplied the law because what it was relating to was paying family. There's a higher standard for paying family because they don't want fraud. They don't want people transferring money and say, "Oh yeah, I cared for her," right? So, but if it's a stranger, if it's not a family member, they didn't have that standard. Well, the local caseworker misapplied it. So local attorney, this is up in Muskegon, the local attorney said, "Okay, that can't be right. Let's go to the local judge, circuit court judge." Circuit court judge said, "That can't be right. That's absurd. You can't impose a penalty for somebody trying to stay off of Medicaid. They're trying to stay off of Medicaid. They're trying to stay in their own home." And the local judge said, "No, that doesn't make any sense." Great. Attorney General of the state of Michigan decided to appeal that decision. And they went to the Court of Appeals, it's like on the Hagedorn case, and they got a unanimous decision in their favor that said that little old Betty Jensen, because she spent $19,000 to try to keep herself in her home over almost a year, was going to be denied Medicaid benefits as a result of that. Who's actually paying that bill, by the way? Because Betty didn't have any money left, right? Betty, by the time she was on Medicaid, she didn't have any money left. So who's going to actually eat that $19,000, that denial of benefits? It's the nursing home. Okay, they act like they're trying to go after these fraudulent Betty's this fraudulent person. She's not fraudulent. She was trying to stay in her home. Okay, and the nursing home is the one that ends up paying that bill, right? Because Betty doesn't have the money. So now the state decided once they won that case that they were going to change the rules. So the rules used to say that the extra standard for paying. Now you can pay for somebody in your home, right? You can pay for somebody in your home, but you got to have, if it was a family member, in the old rules, if it was a family member, you had to have a notarized contract to make sure, and the doctor had to sign it, to make sure that this wasn't fraudulent, right? So the state had misapplied that to non-relatives. So then, since they got this court case, Betty Jensen's court case, they changed the rules, and now it applies to everybody, including home care agencies. And so if you're paying for a home care agency or anybody else or a family member, you need a notarized contract, otherwise it's going to be considered a gift, any payments that you made. Now, we're still fighting this. We're going to fight this battle for a long time. And with advocacy, we've been working around that. Because lots of people are paying for home care, right? And they should be. Absolutely should be. And so we're still fighting this battle out, and we've won. Every single time we've been able to get around that, not having a penalty imposed. But the rules now say that there's supposed to be a penalty imposed. So the state at any point can decide that they're going to start imposing that penalty. And they have. With other attorneys, they have tried to impose that penalty. One attorney fought this all the way through the system, ended up losing at the appellate level, at the fair hearing level. And then, so they lost. So the state got their written decision and then said, "Oh, we're not going to enforce that. We're not going to enforce the penalty." So they know that they're wrong because they didn't enforce the penalty, but they wanted that piece of paper saying that they can enforce that penalty. And the Attorney General's office appeared at that fair hearing to argue that case, right? Okay. This one is crazy, this public guardians thing. Okay. So there's this article in the New Yorker, and I just want to tell you a little bit about this because this is horrendous. So the article in the New Yorker talked about Rudy and Rennie. And Rudy and Rennie were doing fine. They lived in Las Vegas. They lived in their own home. They had a daughter that lived 10 miles away. She visited them every day. They'd never been diagnosed as having dementia. Never. They'd never had an assessment, but a roaming public guardian took it upon herself. Her name was April Parks, and she took it upon herself to go to court and get an emergency temporary guardianship without providing any notice to Rennie and Rudy. And she literally showed up at their door with the police and said, "We're going to move you into assisted living and I have an order from the judge saying I'm in charge now, and go gather your things because we're going to take you there today. Never provided notice to the daughter, who was there every single day and lived 10 miles away. Never provided notice to Rudy and Rennie. Now, eventually, it was a temporary guardianship. So eventually there was going to be a real hearing where they got to have their say. That was going to be 6 weeks later. And a whole lot of damage can be done in 6 weeks. And this actually happened. And so basically what the opinion of the New Yorker is this April Parks was going around, and this was in Las Vegas. She was going around and looking for people that she could become the public guardian for, because now she's in charge of the money. She would move them out into the assisted living, probably somebody that she knew, their assisted living, and she'd sell their house, probably with a realtor that she knew, and then she gets paid to be the public guardian, and she was going out and finding people that she felt needed a public guardian. Now, in Rudy and Rennie's case, they'd never been assessed. The judge never assessed, a doctor never assessed, no one ever assessed them as having needed this care. And they'd never been diagnosed with dementia. And this was happening. And so she actually had, if you ever read the article, there's a picture of her license plate. She had a customized license plate. It read something, it was, abbreviated, but it was like public guardian or something like that. And so she was, and it was, she was driving around in a convertible with a license, driver's license plate. And so now, we haven't seen something this bad in Michigan. Nothing like that. Nothing that bad in Michigan. But there's been a lot of accusations recently. One lawyer in Lansing actually did get disciplined because there was a record of them being appointed by public guardian by the local judge, and them using and basically advancing themselves, using their friends as the realtor, selling the property without the permission of the wards. And so there's been a lot of accusations. There was one that went, in Oakland County and other places. There was the one in Lansing, and these have made the newspaper and things like that. So I'm not, talking out of turn here. I don't know the details on all of these. I knew one of the attorneys involved. I didn't know her very well. She was disciplined for this behavior, and if it's accurate behavior, she should absolutely have been disciplined. But basically, using that position of public guardian to profit themselves. Now, it can happen. Okay. Estate recovery, can they come back and take your house after you die? Well, when this was passed, they passed this rule that said that there's a bunch of exceptions. So they can't be retroactive. You got to have a hardship waiver, and if the house is worth less than 50% of the value of other houses in the county, it should be exempt. And the Attorney General's office decided they didn't like those exemptions that were written in the law. They took it all the way up to the Supreme Court, and basically those have all been gutted. So if you have a low-value house, the state can still come after it. They can retroactively apply it even though they didn't give notice. The law says you have to give notice to the people that they're going to be subject to estate recovery. We argued the case all the way, not me, but one of my groups argued the case all the way to the Supreme Court. Supreme Court said, nope, they can apply it retroactively. And then the law specifically called for a hardship, but they basically gutted the hardship procedure so that it almost doesn't exist. So if you haven't protected the house during the lifetime of the person, there's very little way to avoid estate recovery now. This is one of those things, Attorney, this is what I was saying, that Kelly King Penner has been beating up on the Attorney General pretty good lately. So we go to court on protective orders. The idea of a protective order is to make sure that we don't impoverish the spouse. That's one of the big things. So the Attorney General is showing up on these cases. There's currently a couple cases before the Court of Appeals here, and those cases are being argued out. We have some great attorneys on our side, but they are going through this. Okay, ugly. Not necessarily good or bad, just ugly. Messy, right? So the first one is a trend towards legalisms at the Department of Health and Human Services. We found a lot of denials, and sometimes we're brought in after the fact. So we weren't involved in the Medicaid case, but it gets denied. Sometimes it's even the facility that asks us to get involved and hires us for that purpose. And so we've been really fortunate to be able to take these cases and prove them, but there's a lot of legalisms based on denying because they say they didn't get a form, or they got a form and they didn't feel it had enough information. And so instead of asking for more information, they just send out a denial. And so the problem with that is then they say once the denial is sent out, even when they get up to appeal, they'll say, well, we made a decision based on the facts that we had. Even if I've had Department of Health and Human Services at times say, well, yeah, I see where they're eligible now. They always were eligible, but we didn't have that information at the time, so the denial is still valid. Okay, that shouldn't be the way this works, especially when you're denying it based on a legalism of saying, well, I didn't have enough information, but I didn't ask for more information. And so we've had some of those cases, we've won some of those cases, but this is another thing towards that sort of how to avoid the in the red bed. It's really important that if we're going to argue these cases, that we get to it before we're too far down. Because even if we're at this stage where they have very little money left, if we're able to get through this, if there is any kind of weird penalty or anything like that we weren't expecting, we've got some room so that the nursing home still gets paid. What we don't want to see is where we get to the point where they got nothing and they still get denied. Because we can appeal it, but there's a good chance that the nursing home's not going to get paid for at least partially. So the idea is to get the process started before they're down to $2,000. This is a weird one, and this is again it goes sort of towards that in the red bed. The Medicaid Asset Verification Program. I don't know if any of you have experienced this lately. It's just coming about. You may not have even seen it yet if you do Medicaid applications, but they've got some supercomputer that is going to double check you. Now we scrutinize our clients and we ask them, I don't know how many different ways we ask them how many assets they have, Amy. A good portion of the time I'll go through this long laundry list and ask them about all the assets, and then I'll leave, and then they'll say to Amy, because they don't like talking to me for some reason, they'll be like, oh, well, we got to tell you about this gift that we made, or we got to tell you about this other account. So for some reason, Amy's able to get more information. But a lot of times, you're relying on the information they gave you. And so you file this Medicaid application based on the information that they gave you, and then they're going to run it through this asset protection. But now, we shouldn't be submitting fraud. I'm not saying any of you are intentionally submitting fraudulent applications, but if the family is probably also unintentionally submitting that, I'm all for asset verification as long as it is there. But I'm putting that warning out to you is what you might have gotten approvals in the past based on the information you submitted. Now they've got this supercomputer that's going to be double checking you. And so you might be getting a lot more denials. So just be careful about that. It might be something where you want to get lawyers involved sooner. A couple other weird things. The senior abuse bill. This is a weird one. It's on the fast track to get approved, and it seems like a good idea. Anytime a senior abuse bill seems like a good idea, they made it where it's going to be a presumed felony to have received $10,000 from a senior, somebody over 65. So it's a presumed felony if you're presumed to have committed a felony by receiving $10,000 if you're not related to the person. Problem with that is that kind of turns 200 years of constitutional law up on its axis, right? You're supposed, for a felony, for a criminal law, you're supposed to be innocent until proven guilty. This law is supposedly saying you're guilty until you can prove yourself innocent of a felony, no less. And so in the original law, they had the definition of consent, but the Prosecutors Association lobbied to take that out with the idea that said, well, it's going to be hard to prosecute if we have the definition of consent in there, where the senior person consented to the act, right? And so the Prosecutors Association said, don't worry about it. Well, we won't prosecute the ones that we don't think are really guilty. So we're leaving it up to the prosecutor to decide, whether you're presumed guilty of a felony. That makes me nervous. And it's on the fast track to pass. This is another one. Just yesterday, it passed the Senate. And this is where they're going to put a work requirement, or they're going to try to put a work requirement for Medicaid. We've been looking at this for a while. Now, you have to be able-bodied, but think about an able-bodied person, a daughter who's trying to care for her mom. She quits her job because she wants to care for her mom, because it's her mom. And she still needs medical, right? She's 57, she needs medical. She could qualify for the Obamacare, right, of the extended Medicaid. But this says that she's not going to be able to get it unless she's working 30 hours a week. And so, and there's a lot of other reasons why putting a work requirement on Medicaid is going to be really problematic and hurt a lot of people. Well, this was fast-tracked also, and just got approved by the Michigan Senate. By Michigan Senate. It still has to go through the House and the governor, but it's on the fast track. Validity of documents, there's a couple of things. This is a weird one where an attorney drafted a trust for a friend where he drafted a trust where the attorney was going to get all the money and it was a bunch of money. That's against the rules. It's against the ethics rules for an attorney to benefit himself. And so the question is whether or not that should invalidate the trust. And so that's a big question. And then these are some weird cases where a lot of times deeds, you think you're doing a good thing by drafting a deed or getting a deed form and filling it out, But this is an example where, because the deed missed a couple of words, because they didn't put words in, and they're not words that you would normally use in everyday language, but it missed a couple of words. As a result of that, the house was subject to this Medicaid estate recovery to the tune of $48,000. And if they would just put a couple of words in there, like joint tenants, but who knows what joint tenants? Anybody know what joint tenants mean? Or tenants in common, you know the difference? You don't need to know. But the problem is when people draft their own deeds, this might have even been done by an attorney, but if it's done incorrectly, it can cause all kinds of problems. Same thing with joint bank accounts. The courts have gone back and forth on this and very inconsistent about what it means for joint bank accounts. So some of that seemed a little gloomy, but I like where she's pulling back the storm and it's going to be sunny again. We're here to help. Our slides got all messed up here. This is kind of weird. But so we're here to help, and I'm going to offer you the same thing I've offered for the last 5 years in Bootcamp. I cannot say to the general public, you can call me if you got a problem, okay? I can't do that. But to other professionals, I can. And so that's what I offer you. And up there is our email address and our phone number. And so if you have an issue, and if it's a personal issue, we may say, that's fine, come and see us. It's you need a trust, you need a will, come and see us, whatever. But the idea is if you have a question and you're stumbling on something, you're welcome to call us. Now, we may say you need to contact your corporate counsel. We're never going to take the place of your business's corporate counsel. And so often we might say that. But we might be able to put you in the right direction. For example, we got a call the other day from a skilled care facility, and they said, okay, we've got this client, they've got this health care document, and the person on there is leaving town. And they want to step aside and have the next person in line take over for the health care decisions. Is that okay? And we were able to answer that question. Yeah, here's what you need to do to make sure that happens. Here's how you document it. And they were able to do that without having to encourage attorney fee bill or things like that. So I offer that out to the other professionals, the social workers, people that work in the care facilities and the long-term care agencies. If you need us, we're here to help. Rachel's usually a great resource. Myself, there's 3 attorneys there. So we're always there to help. I am going to ask you for one other thing before Katie gets up here and explains how we're going to get you your certificates for the CEs. So my last thing is, I'd like you once again to take out this orange sheet. And I'd really like you to fill this out, even whether you turn it into us or not, because I'd like you to turn it in, and then we can contact you or whoever you'd like us to contact. But even if you don't turn it in, to really think about it. I'm going to give you a second, because we're a couple minutes early. I'm going to give you a couple minutes here. And so, if you know of anybody that might be eligible for this My Choice waiver, or wants to start thinking about the My Choice waiver in the future, where we could get home care, where we can keep them in their home. Why do you need an attorney for that? Well, it's a great program, but sometimes you need an attorney to advocate to push it through. Sometimes you're just not eligible because there's too much money, and we can figure out how we're going to set up the legal plan to make sure that we're able to keep that money or leverage that money, right? So if you know anybody that would be interested in My Choice waiver, and you can also use My Choice waiver for assisted living, certain assisted livings. Obviously, American House. American House has lots of folks that use the My Choice waiver. So independent living is what I'm referring to. What about an increased level of care? So you get approved for My Choice waiver, and they authorize 2 hours a day. But we really need more. So the example that Rachel gave. So they say, okay, we really need more than 2 hours a day. Well, we can advocate for that. There's a process for that, to appeal that level of care and get more hours. What about something like a simple power of attorney or guardianship? So it could be for you. It could be for your parents. It could be for your sister. It could be for clients. So power of attorney or guardian. Power of attorney is you got competency. Guardianship is you don't. And we need to go to court now. We do that. We've got the staff for that now. Simple will or trust. Seems simple. It's much less complicated than a lot of stuff we're talking about. But if you don't have anything in place and you're over 18, especially since they don't have dower rights anymore, and if you're married and you're not on your spouse's house, it could be a problem. We probably have to have a plan for that. And there's lots of good ways to work around that. Even if it's a second marriage or he's got kids and you've got kids, there's ways to work around that to make sure that everybody's going to get a fair shake in it. But you got to have it. You got to have a good plan. Of course, Medicaid in a nursing home. So if we're looking at Medicaid, if somebody's going to stay in a skilled care facility, That's right up our alley. Anytime if somebody calls up and they say they're in a skilled care facility and they want to apply for Medicaid, we're probably going to get them in within 24 to 48 hours, business hours. So if they call us on a Wednesday, we're probably going to get them in on a Friday. If they call us on a Friday, we're probably going to get them in on Monday. So that's right up our alley. If somebody needs to file for Medicaid and skilled care, that's right up our alley. Medicaid waiver in a home or assisted living. Medicare issues. We had one of the wins I forgot to tell you about. We won a Medicare appeal. They're almost unheard of. Nobody does Medicare appeals for the most part. But we were able to successfully get a Medicare appeal, and it was, to the family, it was a moot point because it was well past the time. They weren't going to get additional services, but the question is whether or not those services should have been paid for. And so we were able to do a Medicare appeal, and we won. The administrative law judge said, yes, that should have been paid for. So the nursing home got paid when they should have gotten paid. And so, and they had doctors, it was the medical director of Blue Cross or something like that on the other end saying, oh, no, that's not allowed. And the judge was like, I don't think you know what you're talking about, sir, to the medical director of Blue Cross. I was like, okay, I like that guy. Veterans benefits, of course. Getting eligible, protecting assets, but also getting through the system, okay? We have, we're very tenacious and about getting through that VA system. So I very much appreciate it. Please take the time to, think about those options of somebody we call this the help someone box, right? Because you're helping someone that might need some of these things. It might even be yourself or your family. You also have one online. In the online materials, there's one that's a little prettier that says, I have someone who may need help. And so if you in the future or a month from now or whatever, you want to print that off, send it to us. We know it came from you. They'll get a free review of whether they can qualify for veterans benefits, a free review of whether they can get waiver or Medicaid or whether they need estate planning. So you can print that off and send it to us. I'm going to bring Katie up, and we're going to kind of conclude the day with how are we going to get these your certificates for your CEs. But I want to thank you very much, and I want to tell you, I'm really honored that you came here today. And the commitment that you show for continuing education and you relying on us to provide that, it really means a lot to me, and I really am honored that you gave up your day, especially a Friday, end of the month. I know end of the month sometimes is difficult for folks that work in the things involving Medicaid. So I really am very appreciative, and thank you very much. Katie's going to kind of tell us the results.